back in our history to find the things that have stood the test of time and polish them and present them again towards the humanity abroad. I feel on a day like this, when you are launching a policy, when you are launching a center, it is really very encouraging that reforms that have been in the making for the last 10, 15 years are beginning to bear fruit. And the more we talk to each other, the less we will have disagreements. The more we talk to each other, the more we understand each other. And let us go and create a better tomorrow for our children. Let us be disruptors. Let us be the next Steve Jobs. Let us be the next especially for the coming generation. Youth is a time for disruption. Let us try and be as disruptive and creative as possible. So on that note, Honorable Minister, I will say welcome to, I think now he will be formally launching the policy, isn't it? Yes, and this center, I believe, is inside. So I don't have the information of the protocol, so my apologies. I just felt that I should say one or two things in honor and in respect of the great presence of the aged speakers here. Thank you very much for your time. Property policy and strategy of the Gambia 2018 to 2023. They are marks with an existing mark and things like that. So if they can know beforehand, probably they would have changed their designs or
so it's a combination of factors. Also, there's also some quasi-judicial functions at the level of the District General's office. But that is why you have to conduct a search before you register.
So that's a revenue source for us as well.
Indeed. Yeah. So if you don't conduct
just like company, before you register, you cite the name,
exactly,
whether it's available to you or not.
Exactly. Okay. So the RG has that quasi-judicial power to advise any applicant that this name exists and so you cannot use it. So, but provided that the person was able to, elude, or deviate and make you register without, going through the normal process. That is where the problem lies. And the law is very clear. You do not have the powers to deregister at that level, unless if you have to go by our new proposed legislation. You only can go to court if quasi-judicial functions do not appear.
Okay.
Yes. Now we want to incorporate that in the new act. Just to avoid, because sometimes you go to court and it takes forever. It discourages people, investors.
So if two registration is done that are very similar and you discover it after the fact, you still cannot deregister one of them.
You have to go to court. And I was one of the drafters of that particular chapter on trademarks with my brother. And we have a feeling the expertise are there, so it is always appropriate that you take advice from the experts. So if the expert is not able to provide advice that will suffice in terms of deregistering an improperly registered mark, then the purpose is defeated. So the proposal there is the RG should be given the powers to deregister, provided it is crystal clear that the second registration is irregular.
Of course, and then the right of appeal will always be there. Yeah. But it will save business people a lot of time or litigation in court.
Yeah.
Because if they end up in court, it takes longer to resolve their difference.
In fact, just to follow suit on that, if you find an irregular registration and you want to challenge it, the back and forth is quite discomforting to someone who wants to move on, because you are required to furnish security, you are required to, there is a time frame within which action should be taken, and thereafter, if you are not able to resolve at that level, then you go to court. So for a businessman who means business, you don't have time for that.
But do you resolve objections to registration when an objection is raised and they are back and forth? You have a decision to make, and I say before it, that is before it.
No, not under this.
So if the party objecting and the applicant couldn't see eye to eye, they still have to end up in court again.
Absolutely.
Even for objection.
Absolutely. If you object to a registration, it means now you are putting me on a hold, not to proceed.
I understand. I was part of the process.
So now, if that happens now, you now who is objecting now need to furnish security to be determined by the registrar general, meaning you put in some monetary consideration. in lieu of stopping me from doing what I want to do.
And then you go to court.
And then you go to court. If you happen to do, then that is forfeited.
So as it stands now, the Registrar General definitely don't have any power to deliver a verdict over any kind of dispute, even at that preliminary stage.
No, it doesn't have the powers of a court.
But I think the examiner can also exempt if he found that the second mark does not qualify.
That is for the examiner.
That is for the examiner. That is
we are speaking ahead of that.
During registration is what I'm saying. He's talking about
what is the right of the applicant if at the level of the examiner he decides, okay, this mark is very similar or a similar mark was already in existence?
The examiner can stop. You can stop. That's why I said if you are able to deviate.
So the applicant can challenge that
absolutely
in court. Also have to go in court.
Yeah.
You can go to court. But the examiner can insist that I will not register you.
Because it does not.
Just like in the case of the companies in the companies register.
Okay.
If you come with a name and we find that the name exists, then we will advise that you cannot register this name. So that one, that's it. So in this case too, there are examiners. When you bring a name, there is a search. They conduct a search and establish that yes, this name exists or does not. And if it exists, then you are advised that you cannot proceed with what they did. But some people will insist that I have extended this, I have done this, I have done this, I have spent more money in this, I have partners elsewhere, they are using the same thing, but that does not exempt you. That cannot be a basis for this.
Honorable Tal, well?
Yes, but I think the good practice now, globally, is to have IP courts.
Specialized courts.
Yes, specialized courts that are going to deal with this so that delays are minimized, but most importantly, the expertise. Because I was in London in 2017, and we interacted with an IP court judge, and he explained to us that business decided that they need these specialized courts, and for them IP is serious business, it's billions of pounds. So
I think both are important, Mr. Tal. If it's both the time factor and the expertise factor, I will give almost the same weight to both of them. I have an intellectual property case that I filed on behalf of a client while I was in private practice. Up to today is not resolved. It's more than 3-4 years in the court. And it involves one of them, the stock that arrived in the country was seized. For 3 years it is seized. We are in court, more than 3 years. That stock may have expired now.
absolutely.
And the case is still not determined. As far as I know, until now it's in the courts.
Not only intellectual property, but also commercial disputes, having specialized courts again to speed up
What about the industrial tribunal? This is supposed to be a business for the industrial tribunal, or the commercial court at the High Court.
Slightly different. I mean, these are mainly
IP and commercial cases, we will
Look at that.
we'll pick it up. Definitely, it's a cause for concern. Like banks are complaining. You know, it takes the nature. Well, I don't know. The media, you people are around now. We are, but it's okay. It's a national issue.
It's okay. Sorry.
But
no, it's okay. We are not discussing anything that is not.
but sometimes us government workers, we want to keep certain things.
But I think the point is that
we are now.
the point is that we all agree that we need to set up specialized courts
For the
IP, commercial,
to expedite the hearing and determination of these matters. Yes, and it is something that government is very concerned about. Right, last time we had a meeting with the central bank, and that is something that we are looking at. Yes. Because the commercial banks too, they complain that it takes a long time. For example, a loan, somebody they gave loan facility to and has defaulted. It takes them a longer time for them to enforce against the person. Because there is, so probably we can have specialized rules and so that even if it goes through the normal trial, it takes longer. We can have rules that can abridge the procedure. Because some of these things are very clear. Security is